Sorry, it appears to be frozen here. All right, we're up and running. Now, let me get back to the Zoom page. Okay. Mr. Mugni, what
Hey,
case
Judge.
are you here for?
So Zachariah Abdulaziz, there was two motions up today. One of them
Oh,
settled.
I thought they both were done. No?
State Farm is still up.
Okay, who else is on that one?
Matt,
Levine?
no, no. Um,
Yeah, I'm not seeing anybody else here. There's one more person in my waiting room. Yeah, I'm sorry, I was misinformed. I was told that Abdulaziz was not going today.
no.
Okay,
Matt
let me go grab
Zambrowski.
it.
Yeah,
Who else is here on Abdulaziz? Here, sorry,
I can call him if you like.
that's fine. All right, I'm gonna pass on yours.
Okay.
Miss Johnson, what case are you here for?
Yes, good morning. I'm here for 250 Bainbridge against Jacob. I'm sorry. Um,
Yep, give me 1 second.
yeah.
That was just the motion to withdraw, correct?
No, it was supposed to be a settlement. Then they have filed for a settlement to withdraw many times, which I wanted to talk to you about it.
Hold on. That was just a yes or no question. Let me pull this up.
Okay.
250. Here we go. People are still coming in. Yeah, I have the settlement conference and the motion to withdraw both at the same time. Who else is here on Bainbridge?
Richard Linnell, counsel for 250 Bainbridge.
You were the one seeking to withdraw, Mr. Linnell?
That is correct.
Okay. Give me 1 second. All right, let's make our record. There we go. I think we got Mr. Smajewski here. All right. Calling case number 23-015069250 Bainbridge versus Total Home Solutions LLC. Appearances, please.
Good morning, Your Honor. Richard Linnell on behalf of 250 Bainbridge Street or ST LLC.
Ms. Johnson, you going on the record?
Yes, this is Serena Johnson from 250 Bainbridge Street LLC.
Oh, so we don't have anybody for Total Home Solutions, is that right?
I'm not aware, Your Honor, of it's a Jacob Kahn.
Okay.
I don't believe he responded to the motion, although I don't want to say that with certainty.
No, I don't see anything. Okay, what is the status here? Mr. Linnell, you were seeking to withdraw. Ms. Johnson, are you seeking to be the new attorney? Is that what's going on here?
I'm seeking for your advice at this point. I called your office 2 weeks ago and I spoke with your assistant Corey because right now I feel I am not represented correctly by Mr. Rick Linnell's law firm.
I see. I'm sorry, Ms. Johnson. I thought you were an attorney. Okay.
No, I'm
Now
sorry. I'm
I'm
the
understanding.
client.
Okay, so you want Mr. Linnell to withdraw?
At this point, yes, but there's they're withdrawing because there's a huge invoice that I've been going back and forth with them. They're not responding to me at all. They're just letting months and months go by and just sending me the invoices, which we have had conversations about a lot of discrepancies, and they're not addressing that. But because I am not paying the full amount that they want me to pay them, that's what they're filing for a motion to withdraw, even though that they have not represented me at all.
Okay, give me 1 second. All right, now that we've cleared this up, hold on. I'm gonna recall the case, Mr. Linnell, because we weren't recording. Okay. Recall in case number 23-015069, 250 Bainbridge versus Total Home Solutions LLC. Appearances, please.
Good morning, Your Honor. Richard Linnell on behalf of plaintiff 250 Bainbridge ST, LLC.
And we have Ms. Johnson. Ms. Johnson, in what capacity are you representing 250 Bainbridge?
I am one of the members, one of the owners of the LLC.
Okay. All right. Generally, I take these motions under advisement to give you time to file to find a new attorney. Is that what you want, Ms. Johnson? I can give you 3 weeks to reach out to another attorney and see if they you can find someone to represent you and proceed with this action.
Well, I was actually seeking for your advice. I don't know if getting another attorney is the right way to go. I just want to have an agreement with this law firm who's not representing me at all. And for the settlement, which is what we were here for, to be addressed, because this case has been going on for almost 2 years. And the only reason why we're here is because you have requested to be in front of you, because I have asked to be in front of a judge since 2023, and they have never filed for that at all. So I don't
Okay,
know.
well,
I don't know what to do at this point.
Well, right now there's a motion to withdraw. I don't know what your issue is. I'm not understanding. You said you wanted to get in front of a judge. For what purpose? You said something about settlement. I don't believe there's a settlement in this case, but I'm not sure.
There was a settlement. We have had a settlement hearing back in September 2024.
Okay.
With one of the attorneys for Linnell and Associates. After that, nothing got resolved. This particular attorney, she left the firm without advising me. Then another attorney came on, which I had no idea. After talking to that person for a month and a half, trying to reach out for like 2 months, no response. That other attorney left. I was not advised of that either. After that, I tried to get in contact with Mr. Linnell. 2 months goes by. I had to chase them. After I had my first conversation with them, they're like, well, you have a balance. I'm like, I've been trying to reach out for months and months and nobody's getting back to me. I had a conversation with him. He said he was going to call me back. He never did. Long story short, we got to talk in March, which I told him there's a lot of discrepancy on the invoices that you're sending. From all those invoices, I'm disputing about $3,000. And after that, they were supposed to review it, get back to me. I sent them the entire list.
Would you like to talk to Mr. Linnell in a breakout room? I have 2 pages here. This would have been a relatively short and sweet motion to withdraw, but I'm afraid that you're raising issues that I'm not familiar with, that I can't decide today.
What I was told that it was a settlement hearing for.
I'm going to put a number on the bill. I'm going to put you guys in a breakout room.
Okay.
See what you can work out. Then
Okay.
come back to me. What I want you to decide is if you want to go forward with this attorney or if you want another attorney. So I'm going to put you guys in a breakout room. You guys can discuss the bills. You now have him here. Give me 1 second. Ms. Johnson. And where's Mr. Linnell?
Sorry, Your Honor, sir, this is not a settlement hearing for my case against Total Home
Yeah,
Solutions.
it's a settlement conference. Go talk to your attorney. And then you
Okay.
guys come back to me and tell me what you want to do.
Thank you.
Okay, Mr. Mugni, do you see who we were waiting for on Abdulaziz?
So I did text him, Your Honor. He said he is in the room.
Who is it?
It's Matt.
Oh,
Yeah.
okay,
I'm here,
perfect.
Your Honor.
All right. Give me 1 second. I have to go grab these. I put them aside. All right. Calling case number 24-000700, Zakaria Abdulaziz versus Ahmed Ishak. Appearances, please.
Morning. Good morning, Your Honor. For the record, my name is Majid Moghni. I represent Zakaria Abdulaziz, plaintiff.
Good morning, Under Matt Zmieski on behalf of defendant State Farm.
Okay, so what motion do we still have that's going?
The motion that's up is State Farm's motion for summary disposition.
Yep. About deck action?
Correct, Your Honor.
Okay, go ahead, I have that.
Okay, so the claims plaintiff is seeking against State Farm is for declaratory order that it is responsible to pay damages on behalf of two individuals or two entities, Nafala Shock and Abuya Trucking. A somewhat brief synopsis of the procedural history is warranted for the motion. The plaintiff was involved in a car accident in 2021. He was a passenger in a vehicle that at the time of the accident was insured by State Farm. Plaintiff filed a lawsuit against Nafala Shock, he's the driver of that car, and Abuya Trucking, who was the alleged owner of that car. Abuya Trucking was the named insured on a State Farm policy. State Farm conducted an investigation and discovered that Abuya Trucking had no ties to this vehicle, that the policy was obtained through fraud and misrepresentation. There's misrepresentations about the owner of the vehicle, registrant of the vehicle, possession of the vehicle, use of the vehicle, garaging of the vehicle, and there was no disclosure that Nafala Shock, who was the driver of the vehicle at the time of the accident, was the owner, was a registrant, possessed the vehicle, garaged the vehicle, and had a terrible, terrible driving history. So State Farm filed a deck action seeking to rescind the policy, and in order to declaring that State Farm did not have a duty to defend or indemnify Abuya Trucking or Nafala Shock for the claims against the plaintiff. Plaintiff filed a motion to intervene in that case. State Farm responded. We did not object to the relief. I disagree with that in plaintiff's response. We responded but did not object to the relief, and the court denied the motion to intervene. So that's State Farm's deck action. Plaintiff tries to intervene. It's denied. Plaintiff then files his first deck action, seeking an order declaring State Farm has a duty to cover the losses of Abuya Trucking and Nafala Shock in connection with the claims plaintiff is pursuing. Before State Farm files an answer, before State Farm files any responsive pleadings, plaintiff voluntarily dismisses the case. Then he files his second deck action. His second deck action is also in state court. It seeks, amongst other relief, in order declaring State Farm has to cover the losses of Abuya Trucking, to cover the losses of Nafala Shock owed to plaintiff in this BI lawsuit. That was filed in state court. It was removed to federal court. Plaintiff then files a notice of dismissal of his federal court case. That notice came before State Farm filed an answer, before State Farm filed a motion for summary judgment, before State Farm did anything. After all of that happens, State Farm's motion in its deck action for rescission is granted by this court, by Your Honor. An order for rescission is entered, and an order declaring that State Farm does not have a duty to indemnify or defend Abuya Trucking or Nafala Shock takes place. Then plaintiff files this case. This is his third deck action. It seeks the same relief that was sought in the first two deck actions, and it basically seeks an order reversing what Your Honor entered in State Farm's deck action. So that's just the procedural background. And State Farm has two motions why it's seeking summary disposition. Again, this is plaintiff's case against State Farm.
Yes.
We believe that plaintiff is collaterally stopped from relitigating the issues on the State Farm policy because this court has already declared the policy can be and was rescinded, deemed void ab initio, and that State Farm does not have a duty to defend or indemnify Abuya Trucking or Nafala Shock for the claims asserted by plaintiff. In State Farm's deck action, this court granted the motion for rescission and declared that State Farm was not obligated to defend or indemnify a Shock or Abuya Trucking for plaintiff's claims, so it was a valid and final judgment. We also believe that plaintiff had a full and fair opportunity to litigate the issue for several reasons. He filed a motion to intervene. While it was denied, he did not file a motion for reconsideration, and he did not file an appeal. After State Farm's deck action was filed, and after the motion to intervene was denied, and before the order for rescission was entered, plaintiff filed one deck action that covered the same exact issues and dismissed it voluntarily. He then filed a second deck action, removed it to federal court, and dismissed it before State Farm filed any responsive pleading. So he's had multiple attempts to litigate this issue before this case, before the order for rescission was entered, and voluntarily dismissed him. The motion for rescission or summary disposition in State Farm's deck action did address issues of balancing of the equities, which is not directly on point for today's motion, but it was addressed in the prior case, and this court granted that motion. We also think that res judicata or federal claim preclusion or the two dismissal rule applies in this case as well. Under Federal Rules of Civil Procedure 41A1, a plaintiff can voluntarily dismiss a case without a court order by filing a notice of dismissal before the opposing party serves an answer or files a motion for summary judgment. That notice of dismissal at the federal court level is without prejudice generally, but if the plaintiff had previously dismissed any federal or state court action based on or including the same claim, that notice of dismissal at the federal court level operates as an adjudication on the merits. Res judicata between federal and state courts exists in Michigan if a plaintiff has litigated the claim in federal court and the federal judgment, precludes relitigation on the same claim in state court based on issues that were or could have been raised in the federal action. Here, plaintiff filed his first deck action and he voluntarily dismissed it before State Farm filed any responsive pleadings. The plaintiff's deck action sought declaration that State Farm is obligated under the policy to cover losses. That same relief was and could have been sought in plaintiff's second deck action that was filed at the federal court level. When plaintiff voluntarily dismissed his second deck action at the federal court level by filing that notice of dismissal, the notice became an adjudication on the merits under the Federal Rules of Civil Procedure. Therefore, because there's been an adjudication on the merits at the federal court level, res judicata, federal claim preclusion, precludes plaintiff from seeking the same relief that he is now seeking in this case. His current deck action involves the same issues he sought in his two prior deck actions. Both of those prior deck actions have been dismissed. The dismissal of the second prior deck action by plaintiff operated as an adjudication on the merits, so we believe that summary disposition is warranted in favor of State Farm under 2.116C7.
Okay, give me 1 second, Mr. Moody. I just have to grab something, and then it's your turn.
Okay.
Okay, go right ahead, Mr. Moody.
So, Your Honor, maybe I'm wrong, but my recollection is there was only one deck action filed against State Farm. That was the one that was filed in federal court. There was a prior BI case that was filed before this court, Your Honor, but that was dismissed because we were waiting to see what Your Honorable Court was going to do on the deck action. So, again, that was my recollection. I don't know which exhibit defendant was referencing as a first deck action. The only deck action that I can recall we filed was against State Farm. It was moved to federal court. It was dismissed from state court because it was removed to federal court. So, and then that was voluntarily dismissed. This is the only deck action that continues. And I think, you know, the arguments made today are irrelevant because it doesn't apply. Because there was only one prior deck action that was voluntarily dismissed in federal court. It was dismissed in state court because it was removed to federal court.
That's it?
Yeah. I mean, as far as the arguments made, so there isn't 3 deck actions. There was the initial one was filed in state court. It was removed by the State Farm to federal court. And then that was voluntarily dismissed. So this is the only one that we've had. So we haven't had 3 bites at the apple.
Yeah, but what about the prior rescission? How is that not res judicata here?
That was the one where we were never a party to. And this wasn't even before you, Your Honor. We filed a motion to intervene.
I'm aware.
And the other judge declined to allow us to intervene. So we filed this deck action because this is the first time that we would get a chance to have the court hear us.
Let me go over the court rules here. Plaintiff made it without a court order by filing. Counsel, I'm reading these court rules and Mr. Mooney, I just think you're wrong. I think under MCR 2.504, res judicata applies here. There was a prior adjudication on the merits due to the dismissal of your deck action. Perhaps I'm not sure where the confusion lies for you, Mr. Mooney. Explain your position again, because this doesn't make any sense to me.
So initially,
I thought I'm sorry, can you pronounce your last name?
Sure. Zimieski.
Zimieski. I don't think I've ever said that correctly. Mr. Zimieski. Okay. I will try to remember it. I think Mr. Zimieski laid it out in the accurate way, but go ahead, Mr. Mooney.
All right, so initially there was a class action filed against State Farm in state court. State Farm responded by removing the class action to federal court. So that was a procedural removal. That's why it was dismissed in state court. It wasn't because we filed an action in state court and then filed the second one in federal court. That was at the doings of State Farm. They removed it to federal court.
Okay. And then what happened to that one?
Then we voluntarily dismissed it. We voluntarily dismissed the action.
Okay, that's one dismissal. All right.
And then this case was filed. And that's the only case that's been filed. So this is the only time that we actually get to make the arguments on the merits. We were never a party to the first action, and that's why we filed it here.
Okay. Mr. Zimieski.
Your Honor, on I guess Exhibit G to my motion, that's plaintiff's first deck action. It's case number 230051004CK. That was before, I believe, Your Honor, or it was, I can't tell. But that
Give me
was
the case number again, because we had the consolidations, but go ahead.
230051004CK.
Okay.
The complaint is attached to my motion as Exhibit G.
And that was the one that was removed and then dismissed?
No, Your Honor. That was
Okay.
the one that was in state court, stayed in state court, dismissed in state court.
Okay.
After all of those three things happened, then the case that was filed, which was case number 230085116NM, that was the second deck action filed by plaintiff in state court. And I agree, that one was removed to federal court. And that's kind of how I laid it out in my argument and in my
And that was
motion.
ultimately dismissed.
Correct, Your Honor. And both
Got
were
it.
dismissed before we did anything, before any responsive pleadings. I think that
I understand. Okay. And that's, Mr. Mooney, how do you get around that? Then there were two. One that was removed and then ultimately dismissed, and the first one that was dismissed.
Your Honor, I think the one he's referencing is the one that we're here on today, but
No, today's the 2-4 case.
the court consolidated the cases.
Nope, there was a 2300600, that consolidation. That's where, with all these filings, that's where my confusion lied. So there were two separate dismissals. And I hate to dismiss cases because I believe everybody gets their day in court, but under MCR 2.504, there are two separate dismissals. Therefore, it operates as an adjudication on the merits, and res judicata applies. Because this isn't, you're saying you weren't involved in, the other one where you weren't allowed to intervene, but these were both filed by you. There's been essentially 4 filed by you.
Correct.
Okay, all right, then I understand it clearly now. Okay. Mr. Demietsky, your motion's granted under MCR 2.504, submit an order. I'm not sure what that leaves us with. Are there any remaining, are there any remaining claims in your 24000700 claim? These are all against Ishak,
No, I think
Via
that's
Trucking, and
concludes.
Citizens.
Yeah, I think that concludes all the cases, Your Honor.
Okay, then I don't have to set a next action date. Okay, all right, submit an order, counsel.
Thank you.
Thank you, Your Honor.
Thank you. Ms. Byers? You are next.
Yes. Yes, good morning, Your Honor, I'm here. This
Okay.
is, okay,
What case?
okay, Malloy, Charles Malloy. I can give you the case number if you need it. Let
Give
me,
me 1 second.
it's 23014-389 NF.
Yeah,
Charlie Malloy.
2304. All right. Who else is here on Malloy? Anyone? Did you receive a response?
Your Honor, as you
Yeah.
may
Okay, there we go.
recall, Ryan's here, okay. What
right.
happened is, you adjourned,
Do I need to call the case or are we just talking informally?
Hi,
Awesome.
Judge. Sorry, I was on
yes, I
another
should call
Zoom.
it.
Oh, are
Is
you
this-
busy right now, Mr. Wagner? Do you want me to wait 5 minutes?
No, I'm in a breakout room on another Zoom, so I can handle this now and then go back to that.
Okay,
Sorry.
let's handle this now. All right, fill me in because I don't have these documents in front of me. There was some confusion yesterday when they were printed up, so this might have been adjourned from last week, but let me call it. Calling case number 23014-389, Charlie Malloy versus Citizens. Appearances, please.
Good morning, Your Honor. Brian Wagner appearing on behalf of the plaintiff, Charlie Malloy.
Good morning, Your Honor. Irene Byers on behalf of the Michigan Automobile Insurance Placement Facility. Your Honor, just to recap, 2 weeks
Please.
ago, we were here on MAIPF's motion for summary disposition based on no fault proofs provided. And at the time, the court issued an order from the court just ordering plaintiff to provide medical bills and proof of attendant care. So by the 20th, which would have been 1 week for them.
Oh, yeah, and we had to adjourn it from last week.
Yes,
Understood.
2
Okay,
weeks.
now
gave them
I'm
a week.
on board.
Okay, so in this time on the 20th, they actually did provide medical bills, but it was only for First Step. They did not provide any other medical bills, and they did not provide any Medicaid lien, and they did not provide any proofs in support of the attendant care claim. As you might recall, this is the one where you were tending to agree that they provided enough just through plaintiff's testimony that he could proceed with his replacement services and wage loss claim. We don't have any written documents, but he did testify to those. He testified, no, he did not
You
receive
froze.
any. Oh, am I back?
I'm sorry, you keep freezing. Hold on. Okay, you're back. I'm sorry, you kept freezing. Go ahead.
I'm sorry, Your Honor. Am I unfrozen?
Yep, you're good to go now. You were talking about the proofs that were submitted via plaintiff's step. Go ahead.
Right. So plaintiff did testify to some lost wages and some replacement services, but he testified that he did not receive any personal care, any attendant care. So we've received no other proofs for the alleged claims that they made at facilitation. So we're still asking that you dismiss his claims for attendant care and dismiss all his alleged medical claims, except for, I understand the first step bills were provided. So that was the only bills provided. There's about 8,000 alleged outstanding. We need to review that. As far as the wage loss and replacement services, I think you already were tending to deny that portion, but we ask that you grant all medical bills other than first step and attendant care. Grant dismissal of any claims other than that.
Okay, I thought you said dismissal of attendant care.
Dismissal of any attendant care claims and dismissal of any medical bills except
Gotcha.
for the only ones we receive first step.
Okay, I misunderstood. Then I thought you argued that, okay, so we still have plaintiff's wage loss on the table and replacement services?
Yes, Your Honor, that's
Okay,
the conclusion that I think you were reaching last 2 weeks
okay, we
ago.
wanted to see what more you had, Mr. Wagner, go ahead.
Yes, Your Honor. As you know, the replacement services and the wage loss, there's sufficient evidence of that based on his testimony. We do have a letter from Optum. They haven't given us the exact lien, so there's no reason to dismiss an Optum lien. We're obviously under a state obligation.
Yeah, you're gonna get stuck with that anyways.
We don't have the amount. We have a letter saying they are asserting one, and they just haven't given us that. And looking at what it'll be, the ER visits he had because he went to the hospital afterwards. That'll be part of it because he testified he had Medicaid. They clearly paid it. The hospitals are very efficient about getting their bills paid by Medicaid if there's not anyone to pay it from a no-fault perspective. So there will be that lien. We gave him the first step that we have. And then we gave him, I know there's a show cause for total tax, so we've given them authorizations for all of these providers. And I think the proper way to do it is if they haven't provided this information under subpoena is to show cause them. And it's my understanding there's a show cause today for total tax because they didn't comply with the subpoena. So I don't think there's a valid reason to dismiss the medical, particularly because we've provided what we have. We've reached out the first step. We've gotten bills to them aside from, they gave us a handwritten bill. We gave them what we had. So,
I remember the handwritten bill now.
Yeah, so
okay.
now,
yes.
right. And they've provided us with a further bill, which we provided to the defendant. We've sought the Medicaid lien. We just don't have it, the exact amount yet, but they've asserted to us and we've notified them. They sent a letter saying they're going to assert it. So I don't think there's a basis to dismiss any of the medical bills, particularly when we've given the authorizations, and we can show cause them. I think it's appropriate to show cause any of these providers that have not complied with the subpoenas for records and medical bills. In terms of the attendant care, he said he wasn't getting attendant care. So I don't know if there was a attendant care claim made at facility, although at the time of his death, he said there wasn't any. I don't know if he's subsequently making one, but I don't think it's valid for a summary disposition. But he did testify he wasn't getting personal care up to the time of his death. So that's not a claim. I don't disagree with that.
Your Honor, I have to please, if I may, briefly respond. Number one, let's just talk about the attendant care. All the claims made at Facil were for right after the accident. So long before his deposition. I fully believe those should be dismissed. Any claim for attendant care should be dismissed. There's been no proofs other than his testimony that he didn't receive it. Number two, as far as medical bills, we're like 2 years out almost on this one. We're set for trial in 2 months. We need to start our trial prep. We need to clear this up. They are responsible. It's plaintiff's burden. If you want to make a claim, you can't just make up numbers and tell us providers. You have to show us a bill. You have to show us it was incurred. The only bill they showed us, first step. As far as the Medicaid lien, I tend to say, yes, if there truly is one, give us a lien. We're two years out almost, way longer than that since the date of loss. Why don't we have a Medicaid lien that you can get from Optum within a week or two if you request it? So I think that
I've never had that experience.
Yeah, it's not a week or two. But
I've never had that experience. Here's what I'm going to do, counsel. First step bill is in, plaintiff's wage loss claims are in, replacement services are in, Optum lien, whatever that may be, that's in. It is plaintiff's burden to show that they submitted these bills and these bills were denied, and you can't do that because you don't have any of the bills. So everything else is out, including the attendant care. With that, I guess the point do you still need a total tax show cause if that bill's out anyways?
Well,
if-
I guess we would. I think I think if they have a bill, they're gonna come after my client, and we did everything we could to get the bill. I don't know why we should be precluded from getting it. If, you know, if they're out, then I don't think we should have to. I mean, they can still come after my client for it, is my point. And if it's obviously the insurance company's obligation to pay it, I don't want to have my client have to pay something because.
Well, no, I'm just saying the show cause is up. Ms. Byers, was that your whole point of having a show cause to get the total tax bills, or were there records you needed as well?
Well, Your Honor, we have nothing from them, but they went out of business a couple years ago. So it's been difficult to get the numbers. But if their bill is out because we've never seen one, we don't even know if there really is one. It was just a number written down somewhere by
Right.
plaintiff. Then I won't need to have a show cause hearing for them because their bill is out. I think that we're coming up on trial. We're either preparing for trial or we're going to come to a resolution here. And as far as that goes, if we come to a resolution, you know,
Mr. Wagner, as we sit here today, no one from Total Talks has shown up, so they're officially in contempt of court. They can put it in the order saying that they're barred from claiming anything as a result of this lawsuit.
That's
Their
fine.
claims are barred.
As long as my client's protected, that
There you go.
I'm fine
That's
with
the
that.
result of the show cause hearing because nobody's here.
Fair.
Yeah, that's the result of that's their contempt of court. Okay, we've got next
Yeah.
action dates, then we're all set.
thank you. Would you like me to
Thank you.
prepare the order, Your Honor?
Yes, prepare
Yeah.
both orders.
Can you
Oh,
submit it to me,
well,
counsel, please?
For review? Sure.
Yes.
Absolutely.
Thank you.
And Brian, how do you want me to do that? Email?
Yes, sir. Yes.
Do you have it?
All
Can I
right.
have it?
I don't
I'm
want to
sorry,
take the
Your Honor.
court's time. Let me call.
Right, here,
you
let me
when
put you
I'm
guys in a breakout room. I
That
gotta
would
keep
be
moving.
perfect.
Thanks.
Thank you.
All right, Mr. Wagner, you guys are gonna go to, I don't think anyone's in room 1. And Ms. Byers, where are we assigned to? Room 1. Okay. Mr. Linnell, you are back. I don't see Ms. Johnson.
She should be coming back, Your Honor.
Okay, then sit tight. All right, Mr. Ryan, what case are you here for?
I'm here for Arthur Stewart versus Farm Bureau.
Do you have a case number? I don't
Yes.
remember them being on my.
2400145 NF.
2400. Oh, give me a break. 1 second.
Yeah, just a settlement conference.
Oh, it's just a settlement conference?
Yes.
Okay, well then sit tight. I'll handle you guys at the end. I'm not sure why I would put a settlement conference on a Friday without a motion, but
Sounds good. Thank you, Your
sit
Honor.
tight. Okay, there's Ms. Johnson. Mr. Linnell, let me recall the case. Here we go. Recalling case number 23-015-069 250 Bainbridge versus Total Home Solutions. Appearances, please.
Good morning, Your Honor. Richard Linnell on behalf of 250 Bainbridge ST, LLC.
And
Okay, and I did see, there we go. There's Ms. Johnson.
Yeah.
Okay, were you able to work anything out?
No, Your Honor. Ms. Johnson made it clear that she has frustration with my firm. We did talk about the bill, although that's not the particular reason that we are here today. And we did actually come to an agreement about outstanding bills, which I'm happy to resuscitate for the record if requested to do so. But based on the motion, I would continue to request that I be permitted to withdraw.
Sure, if you guys couldn't work it out in the other room, then there has been a breakdown. Okay, Ms. Johnson, what I'm going to do is take plaintiff's motion under advisement. Ms. Pearson, that's my court clerk, if you could, I don't see, there she is. If you could send me the Prospe, Ms. Johnson, I'm going to give you, today's the 27th, 1, 2, 3. I'm going to set this case for a special conference, July 18th at 10 a.m. I want you to get new counsel before then or appear in court let me know what's going on, because I can't let Mr. Linnell withdraw until you have new counsel, since this is an LLC. You have to have an attorney, you can't proceed in pro per, but come back to me on the 18th and let me know what's going on with your search for a new attorney and if you want to proceed with the case. But you
Okay, I'm
will,
sorry.
I will get an order e-filed and Mr. Linnell will give that to you.
Okay, you said the 18th, I'm sorry, what time?
18th at 10 a.m.
At 10 a.m. Okay, thank you.
Thank
Yeah.
you. Okay. Mr. Beadle, you appear to be next.
Good morning, Your Honor.
Morning, what case are you here for?
The Tyler Woods case.
I was told those were dismissed.
Well, Your Honor, the Novamed case was dismissed and plaintiff's counsel dismissed, agreed to our relief sought, but technically Linton Chiropractic filed a response leaving to the discretion of the court. So I wasn't sure if.
Oh, okay. So it wasn't, I mean, pretty straightforward.
Yes, it should be it should be quick and easy.
Okay, who's here for Linton Chiro?
That might
No
make
one?
it easier.
All right, that makes it easier. All right, calling case number 24-010233. Give me 1 second. I'm not sure what the caption, since there were multiple filings here. Is that the correct case number? I'm sorry.
010233.
That's what I had. All right. I just want to make sure. There we go. Tyler Woods versus USA Underwriters. Appearances, please.
Good morning, Your Honor. Dylan Beat on behalf of defendant USA Underwriters.
Okay, we were here for the motion for summary disposition. Lynn Cairo did file a response, leaving it to the discretion of the court. USA Underwriters motion is granted. Submit an order, counsel.
Thank you, Your Honor.
Thank you.
Your Honor,
Yes.
if I may, I represent Liberty Surplus in this case. We just filed an answer to the amended complaint about a week ago. I see case evaluations scheduled for July 9th. I was wondering if we might be able to have the scheduling order moved to track 3, since we just entered the case.
Counsel, give me 1 second. I believe the case is dismissed, but give me 1 second. Let me pull this up. You know what, counsel? File a motion. I'm moving on. I'm not going to dig into anything that's not before me right now. I'm not sure what's left and what's not.
I believe it remains open, Your Honor. The MIPF was previously named. I'm assuming Liberty is substituting in for MIPF, so I don't think I'm the only defendant. So if I'm dismissed, I believe
Okay.
you're still
All right.
defendants.
That was
remaining.
my concern. All right. So if there is something that's still moving forward, go ahead, counsel. You can submit an order putting this on track 3.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
All right. Let's see who's left. Mr. Whiteman.
Yes, Your Honor.
Good morning. What case are you here for?
Good morning. I'm here for the Arthur Stewart case, 24-00.
Oh, that's right. I'm sorry. I'm sorry. I was trying to jump around, but everybody got moved around. It was you and I think, was it Mr. Winning? I don't see him anymore. I've got 26 pages of motions to go through. Give me 1 second. There's an easier way to do this. All right, you're here for the settlement conference. Do you guys just want to do this on a different day so that you don't have to keep chiming in while I'm trying to get my FSDs done?
Great. We were just hoping to adjourn till later on. We want to do a global facilitation with all the providers.
Sounds great. I'm still looking for it. There we go. Well, any idea why I put this on? I'm going to look at the notes. My guess is somebody said they were going to file a motion and then they didn't. Settlement. No. Yeah, this was supposed to be up yesterday. I don't know how it got put on the docket today. Settlement conference adjourned to 6/19. It was supposed to be last Thursday.
Sorry to interject. If I'm interrupting, I apologize. My internet is very spotty right now. I'm covering for Daniel Williams for this case. I haven't had an opportunity to speak with brother counsel. My understanding is that Mr. Williams and brother counsel had an opportunity to speak at some point beforehand. My understanding is that this case has already gone to facilitation once, and then there was some sort of hang-up that was reached due to there being, I guess, the policy. There was a limited policy. So now my understanding is that we're trying to seek a global facilitation. And
I understand,
if we
counsel.
could do
I
that-
understand the request. I understand what's going on. I'm trying to figure out
Okay.
how it's on the docket for 6/27 when it was adjourned to
Oh,
Judge,
okay, I'm sorry,
meeting,
Your
which
Honor.
would have
I'm
been
sorry.
last Thursday.
Judge.
Did you guys show up last Thursday and I adjourned it for 1 week to a Friday?
No, Judge.
Whatever.
Last Thursday,
Doesn't
the
matter.
court- Can you hear me?
Ah, the
We were
Juneteenth.
closed.
I
Yeah, so they
gotcha.
moved to the 20th, and because everything from 10 o'clock was adjourned from the 20th to the 27th.
Now it makes sense.
Yeah.
Okay, now I understand. Okay. Then, how much time do you guys need?
Your Honor, if it pleases the court, we would ask to adjourn out to sometime in September. Only reason I ask is that my supervising attorney who's handling this case is out of town for the next immediate for the next month. But his schedule's opened up in September. So that was what I was instructed to request.
Do we want to do, how about September 25th?
That works for us.
Okay. All right,
That
we're
works for
adjourning
us
it.
as
I'm just
well.
gonna put it in the notes for you. Okay, do you need an order sending you to facilitation? Or can you be trusted to get it done?
Let's get
I
it.
believe that, sorry, go ahead, counsel. You probably could speak better to this than I can.
I think we should get an order. We have 5 pending provider suits, so just to get everyone in there, I think it would be beneficial to have an order.
Okay, I will do that. Let me make a note of it. We've got, okay, I'm gonna put you on the books for 9:25 at 10 a.m. Okay. Good luck at your facilitation.
Thank you.
Thank you very much, Your Honor.
Thank you.
Should I prepare the order, Your Honor?
That would be great. Then I don't have to.
Perfect. Thank you very
Send
much.
you guys to facilitation before 9:25 at 10 a.m.
Perfect. Thank you.
Thank you.
Thank you. Have a good rest of your day, everybody.
All right. I have a stack of dispositive motions that I don't know how no one is appearing on them yet, but Mr. McNally, you are next. What case are you here for?
So it's Marlene Vogel.
Yes. I am ready on Vogel.
So we have
Is
a
everybody else ready on Vogel?
and an SD motion.
Yes, Your Honor.
Okay, excellent.
And my client's on the Zoom as well because of the settlement conference portion.
Okay. Calling case number 23-016415, Marlene Vogel versus American House. Appearances, please.
Sean McNally, Your Honor, on behalf of the plaintiff.
Good morning, Your Honor. Michael Kern on behalf of the defendants.
Go ahead, Mr. Kern.
Thank you, Judge. Judge, this is a time and place for our motion for summary disposition in this case. American House, Southgate, the defendant in question here is an apartment building. It's an independent living apartment building. It is not a assisted living building. And I just want to make sure we establish that up front. And the reason for that is the question before the court here today in this motion is duty, and whether or not my client had a duty to supervise or monitor Ms. Hassenrick in her apartment. That's the sole issue for today. The plaintiffs both in their response and throughout the time in this case have made argument after argument that they had a duty to do housekeeping and to take out the trash in the apartment. And had they come in and taken out the trash a day earlier, they would have discovered Ms. Hassenrick on the floor in her shower and would have helped her. That's a proximate cause question. That's not a duty question. Whether or not my client would have discovered Ms. Hassenrick on a sooner date by taking out the trash is a question of proximate cause. What is at issue here for the court today is duty. And there are two questions of duty here. Did my client have a contractual duty to Ms. Hasenrek, or did my client have a common law duty to Ms. Hasenrek? And I believe the answer to both of those questions is no. Speaking first to the question of a contractual duty, again, this is an apartment building. It is not assisted living. And the lease that was signed between the parties spell out very clearly what my client's duties were to the tenant in the building, Ms. Hasenrek. And the duties are to provide shelter, to provide food, to provide light housekeeping and take out the trash. I believe they were providing gas and water, but what was very clearly spelled out in big, bold letters, all caps, was that my client did not have a duty to supervise or monitor Ms. Hasenrek when she was inside her own apartment pursuant to the contract. And this is an agreement that everybody involved in this case understood. We took the deposition of both Ms. Hasenrek and her daughter and power of attorney, Ms. Vogel, and both of them testified in this case that they understood that American House did not have a duty to supervise and monitor Ms. Hasenrek when she was inside her own apartment. Now, the plaintiffs have raised as an issue here, well, they had a duty to go into the apartment every day to take out trash. Well, that's not a duty to supervise or monitor her. That's a duty to take out her trash. And the case law on this is very clear in terms of how we interpret contracts and torts in this country, or in the state of Michigan. And the Fultz case that we cited in our reply brief speaks directly to this. And it says, if no independent duty exists, no tort action can arise out of a contract. So there needs to be an independent duty on behalf of my client to supervise or monitor Ms. Hasenrek when inside her own apartment in order for the plaintiffs to bring a claim here. And there very clearly is not a contractual duty. In fact, it's the opposite of that. The contractual duty, or the contract says specifically, we do not supervise and monitor you. So then the question comes, is there a common law duty for my client to supervise or monitor Ms. Hasenrek in her own apartment? And the answer to that also is no. The law, the Bailey case, which is cited both by the plaintiffs and by us in our motion, is very clear in terms of what it says. And the Bailey case says that when a landlord leases a space to a tenant, the landlord has no obligation to look after or keep in repair premises over which he has no control. So what that means is the space that is the tenant space is the tenant space. And the space that are the common areas, that's the landlord space. And the landlord does have a duty to make sure that the landlord space in the common areas is safe for the tenants. What the landlord does not have is a common law duty to look after what's going on inside the apartment. That is under the control of the tenant. This occurred inside Ms. Hasenrek's apartment, her fault. It did not occur in a common area. Now, the plaintiffs have raised this case, the Kermath case or the Rowland case, however you want to call it, depending on which court, have raised this case and said, well, this Kermath-Rowland case creates a duty in senior living for senior living landlords to look after the residents. And that's simply a misreading of that case. What that case said was, yes, landlords have a duty to maintain the common areas of the apartment or of the building in a safe manner for their tenants. And what landlords in a senior living context have to consider is, what does that mean to keep the common areas safe for seniors in that building? I'm not sure, Judge, if you're familiar with that case, but essentially what happened in that case was
walked out the door. And
Yeah.
She was in a common area. Yeah.
She walked out the hallway and got locked out because the door locked behind her.
Mhm.
And the Supreme Court in that case said, you had a duty to recognize that might happen in a senior living context and make it so that woman could get back in the building because you control that door on the outside of the building. What it did not say is that senior living providers have a duty to supervise and monitor their residents inside their own apartments. And so I think it's a case that's not relevant to the situation here. And therefore, there is no common law duty for my client to monitor Ms. Hasselrink in her apartment, and we would ask the court to dismiss this case.
So
Okay. Go ahead,
Your
Mr.
Honor,
McNally.
the Rowland case is very much on point. They cited factors on how a senior living can must distinguish themselves from essentially from an apartment. And Mr. Kern has up and down has stated that this is simply an apartment, simply a landlord-tenant relationship. But the Rowland case says that that's just not the case. That if you're going to hold yourself out as a senior living, you need to take certain steps and understand that there is a higher duty on that. This is not, again, not just a apartment type relationship. So American House serves elderly residents who need greater support than the general population. They're not going to disagree with that. They agree that everyone at their place is a fall risk. That is one of the testimony of the director of the location in question. They say they'll enter and remove trash. My client was fitted with a pendant like a life alert type pendant, but she wasn't properly trained on it to know that she was allowed to take it in the shower, frankly. And that became kind of the issue here, is that she took it off every time she went in the shower. And because of that, she wasn't able to alert any staff. I think it's important to note this was on the weekend. They're supposed to be in there. They testify that they're in there daily to do the trash. And on the weekend, though, the housekeeping supervisor isn't there. I don't know that there's some factual discrepancy about that, whether that may have contributed to the fact that somebody wasn't in there, is that the housekeeping supervisor isn't there on the weekend. They don't keep documentation on whether they actually entered the room. My client, again, I think she's in the shower, she falls, and she's there for approximately 2 days. She develops serious pressure sore. And so a couple of the main things that they didn't do, and we spelled out all the factors that they within Rowland and the way that this case applies to each of the factors. But factually, a couple of the main things are, again, the not entering the room to do the trash and not teaching her the life alert. And they treat this as essentially they don't owe a duty because it's an apartment. And Rowland says that's not proper. If you're going to hold yourself out to be a place for seniors, you can't make that claim. And yet that's exactly their argument. They acknowledge she's vulnerable, stating that certain facts as to that they were aware she'd miss lunch and things like that. She was 92 years old. So this is, they know that she's potentially a higher risk person there. And I did want to briefly address their reply. They cite this Foltz case, which it's not on point at all. That is a case about a plaintiff. First of all, it was essentially partially overruled or distinguished by a Lowicky case, a Supreme Court case in 2011, number 141168. But that case really has nothing to do with this type of situation. In that case, it was a contractor situation where they're saying that there's no duty between you and an independent contractor that's outside of your contract with a third party. It's simply, essentially, Rowland is the controlling case here. It was from 2022, and it's the one that says, look, the senior livings cannot just treat this as an apartment relationship and think that's enough to get by. And that's what Mr. Kern cites here in every part of his brief, up and down, both parts, is that this is just simply an apartment relationship. Well, it's not. It's a senior living. You hold yourself out in that manner. And Rowland was very clear on that.
Judge, may I just briefly respond?
Go right ahead. It was your motion.
Thank you. Just speaking to the pendant issue that Mr. McNally just raised a moment ago, my client is not in charge of those alert pendants. That's a third-party company that handles those. And they're both run by and responded to by a third-party company. So I don't really think that's relevant here. And then just speaking to what Mr. McNally just said, I don't think any of the points that he made spoke at all to the question of whether or not my client had a duty to supervise and monitor Ms. Hassenrick. And the Rowland case, and I'm quoting it directly, says the landlord has a duty to maintain the physical premises over which they exercise control. My client did not have control over the apartment and therefore did not have a duty to monitor Ms. Hassenrick inside that apartment.
All right, counsel, I realize we have a settlement conference after this. I'm going to take this one under advisement and issue a written opinion. And I will give you a next action date, if and when it's required. But thank you very much. This was a very unfortunate set of circumstances. I want to get it right. My anticipation is that it's going to go up on appeal either way. But thank you, gentlemen. I'll give you a next date if it's required. Look
Thank
for
you,
that
Your
order.
Honor.
Thank you, Judge.
All right, Mr. Malat, you are next.
Good morning, Your Honor.
Morning. What case are you here for?
I'm here on Jaleisha King versus Farm Bureau.
And I believe there was no response, correct?
There wasn't, and Nora Maddie was here for the plaintiff. She called me while you're on the record, and she agreed to stipulate to dismiss the case. So I've just submitted the stipulated order, and just wanted to let you know.
All right, you're all set. Thank you.
Have a good day.
Yep. All right, Mr. Rizza, what case are you here for?
Good morning, Your Honor. Michigan Payne versus Progressive.
Got it. And also no response, correct?
No response, Your Honor.
All right, calling case number 24-014499, Michigan Pain Management versus Progressive. Appearances, please. Go ahead, Mr. Rizza, state your name again.
Benjamin Rizza, appearing on behalf of defendant.
Okay, there was no response by plaintiff in this. This motion is to apply the fee schedule. It's granted, fee schedule applies, and it's also unopposed. Submit an order.
Thank you, Your Honor.
Thank you.
Have a great day.
All right, everybody, you guys were in it for the long haul. Let's see if we can move these along now. Mr. Levine, what case are you here for?
Good morning, Your Honor. I'm here for Central Park South Homeowners Association.
Gotcha. All right. I see defendant is down at the bottom. There we go. All right. Thank you guys for being so patient. Calling case number 25-006522, Central Park South Homeowners versus Camellia Bagley. Appearances, please.
Your Honor, Matthew Levine for plaintiff, Central Park South Homeowners Association, 62160.
Oh, sorry about that. I didn't mean to interrupt you. Ms. Bagley, please state your name for the record.
Camellia Bagley.
Okay, you're the defendant in this case, representing herself. Go ahead, Mr. Levine.
Yes, Your Honor, there are two motions for summary disposition today. Ms. Bagley filed one, I filed one as well.
Yep.
I filed the original complaint on behalf of the association. Ms. Bagley runs a daycare out of the home in the association. There are two clauses in the covenant that we believe restrict certain actions, including running a daycare. So we filed this action to address that issue to prevent further violations. Ms. Bagley filed a response. She filed a counter complaint, and I will say I understand Ms. Bagley is not an attorney, but the responses, the pleadings that were filed were somewhat hard to follow. They weren't necessarily in numbered form. They included various citations that don't exist. Citations to things that don't say what she thought they said. I don't know if AI was used in this, but it was hard to respond to. I believe I responded to all of her arguments. I did not receive a response to our motion for summary disposition. May have been lost in the shuffle. There was Your Honor entered an order regarding Ms. Bagley's motion for injunction last week.
Mhm.
So there were various things being filed. I think there were multiple motions filed by Ms. Bagley under different names. Again, I understand that she's not an attorney.
Right.
That being said, I think the issue is pretty straightforward. The clauses that we rely on are in the covenants. The covenants are contractual. There's no question of fact regarding whether Ms. Bagley is running a daycare. She is. There's no question as to what the covenants say. Ms. Bagley wants to rely on certain laws that allow people to have daycare centers under certain regulations. We understand that the state of Michigan and Canton Township have regulations for daycare services, but regulating daycares or allowing people, citizens, to have daycare centers, they don't negate a contractual obligation. And that's what I think, where I think Ms. Bagley is lost in this. Simply because there is a regulation out there or because these things exist doesn't mean you can't contract your rights away. That's what a contract is. You contract for things that you are legally allowed to do or not allowed to do, but that's what a contract is. She bought this property knowing that this restriction exists and continued to operate the daycare. Now, this isn't a matter of my clients being mean or trying to hold back her primary method of income. Yeah, we understand that it's simply a matter of my clients have a responsibility to enforce the governing documents. They see this as something that is violating the documents, and we came before Your Honor. That's it. In the process, I sent out on behalf of my clients a couple letters to Ms. Bagley saying essentially that we understand your situation. We do believe that this is a violation. We're going to give you a wind down period, but we need you to provide us with proof that there is insurance covering the business. Meaning, my clients have this. They run this. They are the association. There are children at this house that are not residents. There are cars that come in and out every day. What happens if a child gets hurt? What happens if somebody sues my client? Now, my client is insured for various things, but I'm gonna guess that if I'm an insurance company and I see a claim made based upon an action that is against the covenants, I'm gonna deny your claim. So my clients have these concerns. So that was all that was. We were trying to work with her. I received no response from any of those letters. I didn't receive a response until we filed this complaint. Again, I think the counter complaint has a few other allegations that don't concern the actual daycare. I believe I addressed them in my response to her motion. There is no, she hasn't cited a cause of action against my clients, and she hasn't cited a valid defense.
Okay, go ahead, Ms. Bagley.
Okay, I'm gonna have to disagree with the plaintiff. First, as a matter of law, the HOA's own governing documents do permit my use. Their case rests that Section 6.07 prohibits home businesses with public visits. However, the plaintiff's own filings admitted that my clients are a limited group and not the public. So that kind of destroys their legal theory about the public visits. This is not a straight prohibition on home businesses or childcare. It is very narrow, and it says with public visits. And they already admitted that I do not have visits from the public. My clients are contracted, they are interviewed, and I pick and choose who comes. My childcare is not open to the general public. And I believe that their interpretation creates like an irreconcilable conflict within their own contract. It pits the prohibition of 6.07 against 6.01, which mandates a private residential purpose. According to Michigan state law, my childcare is a private residential purpose. 6.03 also requires my childcare to adhere to township zoning laws, which I have fully complied with. There's no dispute with that. And under Michigan law, such conflicts within the covenants must be resolved against the HOA. Secondly, the Michigan law and public policy expressly protects my activity and preempts the HOA's enforcement action. This isn't like a contract dispute. It's I guess, a matter of which policy is more dominant. The Child Care Organization Act, MCL 722.111, explicitly defines my licensed child care home as a residential use. And as in the DCCRs, it says residential use is only for the property, which I am abiding by. And then the Michigan Supreme Court in Bloomfield Estates was clear that private covenants cannot override state law or dominate public policy. I believe the HOA is trying to do just that. If the HOA, even if the HOA had a right to enforce this, which I believe they do not, they barred their own conduct with improper motives, like the waiver through inaction. The HOA, knowing of my child care for 6+ years, I live right next door to a board member, and they have never took action for 6 years. 2021 went in front of a public hearing, Canton Township. No one said, I object to this. It was a public hearing. They were notified. It was open to the public. No, nothing, no violation, no anything. And then it goes beyond just their silence of them knowing through an email that I sent them in 2019 and the public hearing that Canton Township held in 2022. The HOA's ACC committee took an affirmative step, I believe, in improving my pool installation contingent on safety measures related to my childcare. So this documented act they acknowledged and implicitly approved my childcare. And I just believe the timing of this enforcement is highly suspect. It only began after unrelated litigation to a board member and another board member who was recused or forced to resign, who was a VP in 2024 because they objected to the board targeting my business, despite 0 documented complaints, 0 meeting minutes, which I did formally request discovery documents to the plaintiff, which they have not responded to. And the former VP's children still remain within my care and have been enrolled in my care for over 4 years. I just believe that this enforcement began retaliatory, just me living next door to the board members all this time. No one said anything. They knew of these activities. There was a 2024 demand letter. Again, it wasn't a typical inquiry that the board sends out when they suspect an alleged violation. It was just, and then it was followed by a lawsuit. There was no inquiry, there was no nothing. They went straight to nothing to demand letter. I believe it's all litigated in bad faith. That extends to this litigation. Like I already said, they refused to respond to my discovery request. And now they argue these disputed facts. And I just feel like I'm permitted by the DCCR and by Michigan law to have my child care.
Like final word,
Yeah.
Mr. Williams. Go ahead.
A couple things, Your Honor. First, I want to address the so-called admission that her clients are not the public. She's referring to my response to the motion for injunctive relief. I was addressing the factor of public interest in regards to injunctive relief. I said that I think her claim was that her clients were the public, and so therefore having a daycare benefits the public interest. I said for purposes of injunctive relief, they are not the public because I believe there's only 12 people. The injunctive relief factor is the public at large, the world, or the community. So we did not admit that her clients are not the public. The public, in regards to the covenants, refers to people who are not members of the community. Her daycare requires people on a daily basis to come in and out of the community. That's specifically what's banned in the covenants. Briefly, the discovery request. Ms. Bagley did not file initial disclosures. As Your Honor knows, you can't seek discovery if you don't do initial disclosures. So yeah, we did not respond to it because they were not proper. As far as retaliation, no, this has nothing to do with retaliation. I don't know any of the board members that were involved in a prior lawsuit or have children at the daycare. They have not been involved in decision making because of any potential conflict. That's the proper way of running running this thing. There's no waiver. There's actually a clause in the covenants to say that there is no waiver if there is a mistake made, or if the board did not try to pursue enforcement in other areas. By the way, the statute of limitations for enforcing a covenant is under 600.5807 subsection 5. It's 10 years. As far as whether or not Miss Bagley is complying with local ordinances or state law, she may be. I don't know. This is not an ordinance action. I don't represent the township. I don't represent the state. I represent a party to a contract. I'm sorry, Judge, you're frozen.
Uh-oh.
Did you?
Mr. Levine, you froze.
Yeah, am I back? You hear me?
You're back now.
Okay.
It's saying my connection's unstable. That concerns me, but yeah, go ahead.
There's no question about whether or not Miss Bagley is complying with state ordinance or state law or local ordinances. I don't represent the state. I don't represent the township. I'm not a neighbor trying to claim a nuisance per se. This contract, the covenants, existed before she applied for a license. By the way, as far as the 6 years that she's been running the daycare, I want to point out that technically she may have been involved with a daycare for 6 years, but Miss Bagley only became the owner of this property last year. Now, she lived there with her husband, I assume, her former husband. The property was in his name only. This is not just a technicality, it's property law. She did not own the property, therefore she was not a member of the association until 2024. As far as us not sending notices or something before the letters that I sent, well, yeah, I sent letters giving her the opportunity to correct the situation before we filed a lawsuit. No response. I sent another one. No response. My clients have legitimate concerns about this. And as far as public policy, the case that I cited, Tarian versus Zwit, which I know Miss Bagley relies on as well, but I think she did not read the case, because the case specifically says that there is no known public policy favoring daycares. There is a public policy favoring covenants and to property. It also talks about daycares, and that a daycares are not permitted if the contracts, the covenants don't allow for them. Our contract does not allow for a business, a commercial enterprise that requires people from the public coming in and out. That's it. That's the only relevant part of the contract. This the previous one, 6.01 talks about each property can only be used for private residential purposes. This isn't a private residential purpose. She has business being run out of the property. Now, I do understand that the statute 722.111 talks about private daycares, private homes, and residences, but I also know that 722.111 says as used in this act. So it doesn't mean universal. It's not making definitions for everything. When we're interpreting a contract, we have to use a common understanding of the words in the contract. The common definition, a common understanding of private residential use is it's used for your family, the owner of the property, as the common use of the public entering the property is this. It's people, her clients driving in and out, dropping off their kids and letting them stay there for extended periods of time. As far as whatever happened at board meetings or a request for a pool, none of that is relevant. Again, there's no waiver. The contract specifically says that there's no waiver if something is not enforced. My clients are not, this is not a for-profit business. They're volunteers. They're not out there policing the community. They don't have a police force. They're not out there, making sure everybody's in compliance with every single thing. However, when something comes up and then they run across they compare it to the contracts, they seek legal advice, they're obligated to enforce the contract as it states.
All right. Ms. Bagley, this is unfortunate because I don't want to ever put anybody essentially out of business, but these are covenants that are enforceable, excuse me, under Michigan law. Therefore, Mr. Levine's motion is granted, your motion is denied, your counter complaint is denied, And Mr. Levine, what was your suggestion and proposal? Because it might be better than mine as to when she has to wind down the business.
Judge, I'll have to talk to my my clients about that because this was last year that we sent it. I think we had given her a year at that point, but I have to look back at it. And it was contingent on, again, having that insurance policy that covers my client, a hold harmless, because that's one of the primary concerns for the community.
Well, that was far more reasonable than mine. I was going to give just a matter of months. So at this point, I'm going to give 180 days to wind down the business, and it needs to be stopped. That's unfortunate. Put that in the order, Mr. Levine.
I will draft an order and submit it under the 7-day, Your Honor.
Thank you.
All right, thank you.
All right, Mr. Razad.
Good morning, Your Honor.
Morning. What case are you here for?
I am on number 24-011684, level 1 physical therapy for underlying claimant Proctor. Now, you'll have to forgive me. My understanding was that this was set without oral arguments, but because of just the history of the case, I would there was a motion to set aside that to reinstate the case that was granted. We filed an opposition, but we were never notified and we never received an order on the court's ruling. And so then we got a default because we never got an order. And so I just wanted to appear to make sure that the court does have my appearance. If the court does have a ruling, I just wanted to make sure that this didn't get somehow missed by my office or.
Well, can you give me the case number again?
Yeah, I'm sorry. It is 24-011684NF.
Okay, give me 1 second. Yep, that's up at. Oh, that wasn't up today. Let me look it up.
I apologize. That the precipice I have noted today, but did say without oral arguments.
Okay. 24016814. Was that correct?
Nope. The 6 and the 1. So it's 011684.
Oh, maybe it was up then. I was looking in the wrong spot. Sorry. My
Oh, that's
document sheet is 26 pages long, so.
And like I said, Your Honor, the precipice did say without oral arguments.
Oh yeah, here we go.
For that history that I just told you about, I wanted to make sure I crossed my T's, dot my I's, and.
Yep, it's without oral argument. If I need to hear from you guys, I'll order you guys to appear next Friday.
Okay, so I just wanted to confirm with the court because the whole reason we got into this situation and we got a default is because like my office never got the order for the reinstatement letting us know about that May hearing that resulted in the default. So I just wanted to make sure whatever the court rules, I'm hopeful that it'll be granted due to the the clerical errors here. But that I don't miss another deadline. So does the court know that? I had filed my answer and appearance, but I having not received anything previously, I just wanted to.
Are you here for Liberty Mutual?
Yes.
Yep. You're not in the system. So get your appearance in. Yeah.
Refile my appearance. Okay.
I would. I don't know. I can't explain why you're not in the system, but you're not listed. Let me see. We have a miscellaneous pleadings as of June 4th. Nope, that's a supplemental exhibit. No, I don't see you in the system. So get your appearance in. That's probably why. Let me see if maybe they're just. Do you have any idea when you filed it?
Yeah, well, so my appearance was filed with our initial response, and that was filed back in April 17th.
I don't have any filing as of April 17th.
Oh, that was our.
I have a motion to set aside on April 7th.
Yep, and then we filed our response on the 17th.
Nope.
I mean, it's showing is filed on my end.
Not on my end.
Oh.
Yep, it's not in there. So I'm not sure what to tell you, but I would get your appearance in.
Okay. I'm getting that. I'll file that right now.
Okay, perfect.
Thank you, Your Honor.
Yep.
Bye-bye.
No problem. Mr. Saad, what case are you here for?
Good morning, Your Honor. I'm here for case number 24000547NF.
Give me 1 second. 000547. Specialty Medical Center. All right, I don't know why. Again, I'm not sure why they're putting final pretrial conferences on a Friday, but give me 1 second. Let's see what's going on here. Yeah, final pretrial was for May 29th. Let me look in the notes here. We're dealing with, oh, it was adjourned to 6/19. Okay, and we didn't have court that day. All right, that's probably why you guys would have never gotten a notice. Do you want me to just issue an order getting everybody here next week?
Sure, that's fine.
Nobody else is here. What day works for you? Want to do next Thursday?
Let me just double check. Yeah, that works.
Okay. All right. Okay, I'll issue an order so that they get served with it, and we'll do it next Thursday.
Thank you, Your Honor.
Thank you.
Have a good day.
Yep. All right, let me stop the recording.